Hi, I'm Jay from Personal Bar Prep, and this is Simplified, our series designed to simplify tough subjects on the California bar exam. Today, by listener request, we're going to simplify personal jurisdiction. So let's get started. Personal jurisdiction refers to a court's power to hail a party into court. Typically, this is only an issue for a defendant in a civil trial because the plaintiff is the one that chooses the jurisdiction, and therefore they are clearly consenting to jurisdiction in the forum state. So the issue arises, what about a defendant? Can all defendants just be brought into any court in any state? And the answer is no. This is a due process problem, and it works as follows. First of all, there are traditional bases of jurisdiction. If these exist, then automatically the state court or the federal court sitting in the state will have jurisdiction over the defendant. These are as follows. Number one, where the defendant is a resident of the forum state. If you live in California, you are clearly subject to the court's jurisdiction in the state of California. Similarly, if you are served with process while in the forum state, unless you were brought there merely for the purpose of process and to defraud you, then the court will have personal jurisdiction over you. Next, if you make a general appearance in court to respond or answer the complaint, you have consented to jurisdiction. In order to object to jurisdiction, in federal court, you must either object with your answer or prior to your answer, and in state court, you make a motion to quash or a special appearance for the purpose of questioning or challenging personal jurisdiction. If, however, you make an appearance, then you have consented to personal jurisdiction. And finally, where you have consented previous or prior to the lawsuit, if you've consented to jurisdiction in the state will have jurisdiction over you. Those are easy. Those are generally not tested because they are so straightforward. The problem arises where you don't have any of the traditional bases. And then we have the following issues to resolve. First, is there a long-arm statute? A long-arm statute is the state's expression of the limits of its power to exercise jurisdiction over out-of-state citizens. Generally, the bar exam doesn't give you a long-arm statute other than one that goes to the full extent of the Constitution. If you do get some other long-arm statute, you're going to have to analyze it using the facts. It's never been tested that way. I doubt it'll be on this bar as well. The next question you have to ask yourself, if there is a long-arm statute, is it satisfied? If there is no long-arm statute, then just say, assuming this state has a long-arm statute, then the analysis goes to the constitutional due process issue. Because not only must the state have a long-arm statute, but that long-arm statute must not offend traditional notions of fair play and substantial justice. And in order for that to be the case, the defendant must have some degree of minimum contacts with the forum state, such that hauling them into court in the forum state will not offend traditional notions of fair play and substantial justice. So then the issue arises, what do we mean by minimum contacts? What we mean by minimum contacts is the defendant purposely availing himself of the benefits of the forum state. By purposely going to the forum state, you are vulnerable to injury in that state. Therefore, you also have the ability to seek the protections of the forum state, be it their hospitals, their roads, their laws, their emergency services, etc. If you have purposely availed yourself of the potential to use those benefits in the forum state, you are said to have purposely availed yourself and thus have minimum contacts. Now, minimum contacts can be defined in two ways. You can have continuous and systematic contacts where you regularly have contact with the forum state. For example, you deliver products on a regular basis to the state of California from outside of California. Say you deliver Coca-Cola every day, 5 days a week, and you've been doing it for years. Those are continuous and systematic contacts. And where one has systematic and continuous contacts with the forum state, they are said to be at home in the forum state, and then the forum state will have what's known as general jurisdiction over that defendant, such that they can be sued for anything at all within the forum state. But let's suppose you have sporadic or very limited contact with the forum state. Clearly, you have purposely availed yourself of the benefits of the forum state, but it's only once or twice. For example, you export goods to the forum state, and you've only done it once. That is a single contact. It is sporadic. It is clearly not continuous and systematic. So now we have to analyze, not only is there a contact, and did one purposely avail themselves of the benefits of the forum state, we then have to ask whether or not it comports with traditional notions of fair play and substantial justice to bring this defendant into the forum state. And in order to do that, we ask ourselves, based upon the contacts, is it foreseeable that this defendant might be sued in the forum state? If so, it appears to be fair. Next, we have to analyze the interest of the parties and the interest of the state and the interstate judicial system to determine the fairness of hauling the defendant into the forum state. So first we look at what are the plaintiff's interest in being in the state, and we are very deferential to that because the plaintiff chooses the forum where the plaintiff decides to sue. Next we ask, what is the defendant's interest in not being in the forum state? We then ask, what is the state's interest, which is typically to provide a forum of redress for their own citizens. And finally, and to a much lesser extent, what is the interstate judicial system's interest here in judicial economy? Once you've established that it is fair by showing that the defendant's interest in leaving the forum is not as great as the state's interest in hearing the case and of the plaintiff's interest in being in the forum, then what you've established is that it is fair. Now the only question is, does the lawsuit arise from the contact? Because where you have sporadic contacts, the only thing you can be sued for in that state is conduct specifically related to the reason you were in the forum state. If you are sued for something else, and all you have are sporadic contacts, and you're not being sued for those contacts, the state will not have jurisdiction to hear the case or to haul you into court unless you've had continuous and systematic contacts, which then gave rise to general jurisdiction. But where you only have occasional, sporadic contacts, then the court at most has specific jurisdiction, and then you can only be sued for actions relating to the contacts you had with the forum state. Once you've established that, you've then established that there is personal jurisdiction over the defendant. If you enjoyed this video and you found it helpful, leave a like or share it with others. If you have questions about the topic, leave a comment. Personal Bar Prep is the small group California bar prep company. If you like this video, you'll love our course. The link to our website is in the description below. Thanks for watching.